If you are starting to stack up some comments that are unsavory, they could be directed at pregnancy, they could be directed at age, they could be directed at any slant, then that could be a sign that they're looking to terminate you.
Oh, absolutely. I mean, that is evidence of their discriminatory intent. And it's important to kind of document these, like just keep your own diary, keep your own record of what happened. These can be useful to use later, because what will happen most times is that if you come to the company, let's say you're being demoted or you've been terminated, the reason was discriminatory. Well, the company's going to say no, right? The company's going to say, well, the reason was you weren't a good fit. Your performance reviews had dipped, or any number of reasons. It's what we call pretext. It's a made up reason to cover up their discriminatory intent. And then those snide comments, those things that have been made that you've kept a record of, can be used as evidence of that intent. You can be like, the reason that you fired me was because that I'm pregnant or I'm over 40. And the reason I know that is because my manager on this date said these things.
The idea of job security is outdated as a landline. If you haven't been in a search for a while, it's probable you will at some point, by choice or not. Most executives admit to staying way too long, or sense what's coming and justify staying anyway. Here, there's another reason. The faulty belief that navigating to what's next will inevitably be worse and has to suck. Screw that. Lauren Greif has spent a lifetime in corporate and executive search, calling bullshit on stale career advice that most still use. This is Career Blast in a Half, the career podcast for executives ready to cut past outdated career advice to fuel your outcomes now. So let's go.
Have you ever woken up in the middle of the night and thought to yourself, yikes, I'm afraid I might get fired? You have that stinking thinking that is going on, and it's consuming you. And that's why we brought in Tom Spiggle today to talk about this very topic. Tom is an attorney, and he doesn't play one on TV. He is a real one, and he is a graduate of Georgetown Law, but he also focuses his practice on all things related to employees, including things that relate to termination, discrimination, including ageism, and also non-competes. And I am so thrilled to have you here as this resource, because this is not going away, and I'm sure it consumes your every single day with people that are being let go or fired or thinking about getting fired or consumed with thinking about they're getting fired. In your book, Fired, Afraid You Might Be, you dive deep into this topic. And so I would love for you to talk about what was it that got you so inspired about being fired?
Yeah, no, and thanks for having me, Lauren. I really appreciate the great work that you do, including this podcast. I'm honored to be on it. I think I've always been drawn to the employee side because I really hate a bully. I don't like people who abuse their power, and most employers don't, right? But some of them do, or even if the employer doesn't, they've got a rogue manager who's taking advantage of his or her position to mistreat people, to bully them, and of course we all know we all depend on our jobs for our livelihood, and so it's can be super debilitating to have somebody kind of yank the rug out from under you. So I've always been drawn to the underdog in that situation. So that's why I kind of got into the employment law field and wanted to exclusively represent employees.
Mm. And so walk us through kind of a expected phone call that you might get with somebody that is in fear of getting fired, and or maybe on a PIP plan, a performance plan, which can be not necessarily always an indicator that you should be looking at the writing on the wall, and or has been terminated. What does that sound like? Hey, I'd like to talk to Tom. And then what do they say? And then what is that course of action that they need to hear from the very onset? So they've never done this before. They're green, and they're also fragile.
Yeah, absolutely. It's a great question, and we do get that call pretty frequently. And so the first thing is usually the person has right there in the lost, right? They have no idea, what's going on or how to handle it. And so that's the first part, is just sort of orienting them. First of all, in this hypothetical situation, good for you for calling an attorney, because a lot of people don't, and they suffer in silence. And I think people are sometimes intimidated by attorneys, or thinking if they call one that the attorney is going to grab them by the elbow and run off to court to file a lawsuit. And that's just not true. I mean, most of us who take those calls from people who are still at work, we're helping them assess their situation. So let's say, you've been put on a PIP, and you're trying to decide, like, where do I go from here? Do I have a legal recourse? We start by giving them the lay of the land. Like, what, for example, like, usually being put on a PIP in and of itself is not illegal. You can't sue your employer for being put on a PIP. You can sue them for what happens after that. And as you mentioned, Lauren, a lot of times, if you're put on a PIP, that's the first, just the first step to getting fired. A lot of people don't recover from that. And so, then we discuss, are there other areas of leverage that this employee has something, is the fact that they're put on a PIP, for instance, we talked about ageism or some other kind of discrimination, is that the basis? And then we can talk about, what's the strategy? Do you, as the employee, want to go raise this with HR, which will put yourself in the strongest legal position, but also makes being at work very difficult and often results in your eventual termination. And certainly things can become very uncomfortable in the meantime. What that's going to be like, and whether or not they want to take that action. And then another thing that I like to do in my practice, and one of the reasons that you and I got introduced, is that a piece of it has to be, you're looking for that next job. So I like to combine my services with working with somebody like you, or a career professional who can help somebody, make that leap in the best way possible, because we can help deal with things at work. We can help with the rear view mirror, but we're not designed to look forward, at least in the sense of, like, helping you find another job. So I would say those are the two things that I really focus on. Where are they right now? What are their options? And what's their best plan for getting out of there?
The Phoenix moment, right?
Yes, the Phoenix moment. Absolutely.
So the Phoenix moment, Tom told me the last time we spoke, is, that next iteration of what's next. So, you're here when they might get a PIP, but what are some of the other flags, maybe more nuanced? Because, I mean, if you're on a PIP, you can't be in denial that this is never going to happen, right? Like,
Sure.
you gotta look at it squarely. But what about the other more nuanced clues or tips that say, hey, by the way, you better watch out?
Yeah, no, it's a good point. And a lot of times it is very subtle. A PIP is a pretty hard marker, right? But another one that we see is, let's use the example of pregnancy discrimination, which is one we unfortunately see pretty regularly. And so you get pregnant, and you come back from your leave, and all of a sudden the things that you were doing before don't seem to be sitting as well with your management. And all of a sudden, the 30-year-old single guy down the hall seems to be getting better assignments, seems to be getting more
Mm.
time from upper management. You're reading the tea leaves that things have changed at work, and the only thing that's changed is the fact that you got pregnant and then came back from leave. And so those sorts of things can be evidence of discrimination. And if
So
somebody
wait, I
calls
just
me,
want to. So
yeah.
so your workload has been parsed out or reallocated to somebody else. Is like, all of a sudden you have a lot of empty empty time on your calendar. Is that like an indicator?
Yeah, absolutely. That's a great indicator that the company is getting ready to make a move. And even if you're not going to be fired, you've been sidelined, and your career trajectory is not going to be the same. So, if somebody calls me in that situation, like, I would help them parse through what's happening, and whether that's strong evidence of discrimination, or whether they need to kind of let it ride for a little bit and see what happens. Try to coach them through, if they decide they're going to talk to HR about it, like, how they're going to do it. There's kind of the soft approach, and neither one of these is necessarily right or wrong. There's a soft approach. You kind of go and you say, hey, I'm back from leave. I want to make sure I'm being, back to my same level of performance, and want to see if there are any concerns, like being very proactive and not mentioning your concerns about discrimination. That's one option. The other option is to be straightforward about it and say, hey, I am concerned that I am being discriminated against on the basis of my pregnancy. And the strategy behind that is, if you raise pregnancy or any kind of discrimination, it's called protected activity. That's the 25-cent legal word that we use. If you raise that protected activity, and the company then does something to you afterwards, they terminate you or continues, to continue to sideline you, then you have two claims. You have the underlying discrimination claim, and you have a retaliation claim, which are often the stronger claims to bring, because it's just a matter of a timeline, right? Like, this happened, I complained, and then that happened. So
Mm.
those are sorts of the things that we would counsel
And
people
you
on. Is
complain to HR? You bring that to HR?
Yeah, HR, or it could be to management,
Okay.
but HR is usually the bigger one. And if you're going to do it that way, as always, it's better to do it in writing, because then you can point to, hey, I sent the email. There it is, the date stamp on this date, and then 3 weeks later I was terminated, or 3 weeks later
Mm.
I was demoted,
Okay.
or whatever it may be.
Aside from being sidelined or being taken out of your workload and empty calendars, what are the other clues that say, hey, knock, knock, you got to pay attention here? Anything else?
Sure, comments, right?
Mm.
Comments usually, like a standalone comment is usually not enough to rise to the level of being illegal, but it's certainly a sign. And if you get those repeated comments, let's say, again, let's use the example of, someone that, let's say they have a disability and they have to leave for medical treatment. And the boss is like, hey, must be nice to leave at 5:30, or it makes those kind of repeated comments when the reason you're leaving is because you're going to get treatment for your disability, which the employer in this instance, let's say, knows about. So those kinds of, it doesn't have to be as concrete as, they've taken away your direct reports, or they've lowered your salary, or they've done really concrete things. It can be just how you are treated in the organization. And again, the straight comment like that is not enough to rise to the level that I would file a lawsuit over, but it is an indication. And if those kinds of things continue, those can all be circumstantial evidence of discrimination. And, I
Oh,
think for somebody in that situation, certainly to be talking to a lawyer. And again, the lawyer's not, I mean, they're in the, we often do this. We're behind the scenes. We're not talking to your employer. Nobody knows we're there except you. And then the other piece is, start looking, go
mm.
work with somebody like you, go work with another career professional. Like, don't get caught flat footed, use that time to start, whether you leave or not. It doesn't, as it doesn't hurt you to,
Be
to have
proactive.
your best foot forward and have options.
So, what I want to just go back and rewind on for a second is, if you are starting to stack up some comments that are, I'll just call them unsavory. They could be directed at pregnancy, they could be directed at age, they could be directed at any slant, then that could be a sign that that they're looking to terminate you.
Oh, absolutely. I mean, that
Okay.
could be, that is evidence of their discriminatory intent, right? They're giving
Right.
you, maybe unknowingly, a little window into what they're thinking. And it's important to kind of document these, like just keep your own diary, keep your own record of what happened. These can be useful to use later. You can put dates and times, even just for yourself. You're not sending
Right.
these to anybody at this point. You're just keeping record yourself of dates and times, because, what will happen, often, most times, is that if you come to the company and you say, hey, let's say you're being demoted or you've been terminated, I think the reason was discriminatory. Well, the company's going to say no, right? The company's say, well, the reason was, you weren't a good fit, or your
Mhm.
performance reviews had dipped, or any number of reasons. It's what they what we call pretext. It's a made up reason to cover up their discriminatory intent. And then those snide comments, those things that have been made that you've kept a record of, can be used as evidence of that intent. You can be like, no, like, the
Right.
reason that you fired me was because that, I'm pregnant, or I'm over 40, or you fill in the blank. And the reason I know that is because my manager, right, on this date, on this date, on this date, said these things.
Yes. It's uncomfortable. I've been in situations like this where you have to document it, but it is a lifesaver because if you don't have proof points, and this goes for a lot of other things, right? You can't just make a claim on your resume. You can't just
Right.
make a claim in an interview, because that's your integrity on the line, but it's also the basis of being able to make some traction if it is something that you are going to pursue any kind of legal counsel around.
Yeah,
And so
absolutely.
note taking shouldn't be a big aha, but I think sometimes when we're in those situations and we're emotional, we're like, was that really this or was that really that?
Right.
And so pay attention to that, I think, for sure. And so
Well, and
let's
just
just
to real
say,
quickly on that, I mean, I
please.
think a lot of people are understandably confused and think that, it's just what you hear this all the time. Like, I can't win a he said, she said case. And I get that. In an ideal world, yes, you'd have a smoking gun, you'd have the email, you'd have the memo, you'd have something like that. But you don't need that to win a case. You can
Mm,
just comments alone, what people say alone, what somebody does alone, whether they're witnesses or not, can be the basis to win, to win a case. I mean, I used to be a prosecutor, did a lot of sex offense and domestic violence cases, and sometimes the only evidence I had was what was recounted by the victim because there was nobody else there. Right? Maybe
mm,
it was a while afterwards, so we didn't have pictures of bruises, or we didn't have a rape kit, or those sorts of things. And I still won those
mm.
cases, as did other prosecutors, at a much higher standard, beyond a reasonable doubt, because it just becomes what can you convince a jury or a judge that this happened? And we're people, right? We've all been, we've all had our human experiences, and we can read those situations and can judge, like, do I believe this person? And if you are telling a very compelling and detailed narrative of what happened, the jury can be like, oh yeah, I can see that, you can win those cases. So I think it's
Okay.
important for people to
Oh,
understand that can be very powerful evidence.
thank you. Thank you for helping us to not talk ourselves out of it because we have a storyline that says, "Oh, it's going to be he said, she said," and no,
Right.
you could still win a case. So now what I want to kind of move over to is you've been let go. It's done. It's happened. And now, I mean, in our conversation leading up to this, what I really respected most is that you help people understand whether it really is not only worth it, I'm not just talking about financially, I'm also talking about emotionally, to pursue this case. So let's just say you've been terminated, and of course, you're not feeling like at the top of your game. You're probably feeling a little salty. And and
Absolutely.
and that being said, you might be feeling very litigious and guns a blazing. And so, how do you handle people who are very emotional and ready to rip a new one to whoever is on the other side of the desk? And how do you discern whether or not, of course, inclusive of the actual cause, that this is worth pursuing? How do you know when this is really something that has to be done?
Yeah, I appreciate the question, because you're exactly right. It really is a kind of a nuanced decision, and there's often no right or wrong, and no factors are the same for each person. So if somebody comes to me, I think the first thing to understand is that, as you say, if you've been fired, the blocks have been knocked out from under you. If you've been offered a severance, you've got this 5+ page document of legalese, and you're confused by it, and maybe your employer is giving you a deadline to sign it,
Mm.
or you don't get your severance. Just to decide, if you're over 40, they have to give you at least 21 days, and then you got 7 days to change your mind even after you sign it. If you're
Whoa.
under 40, you're out of luck. You don't have those protections. But a lot of people are, feel like a real rush to take action. And certainly there's a consideration of whether or not you want to. A lot of people need the severance, right? You got to decide whether or not, that's something that you need to take, or you're in a position that you have to take. But as a legal matter, depending on the state that you're in, you've got, for various reasons, either 180 days or 300 days to bring your claim before you lose it. So let's say you're in a situation where you don't have a severance offer. Like, there's no rush from a legal perspective to take action. So take your time. A lot of people, what I tell people is, take your time, take a deep breath, collect yourself for however long it takes, to weeks, months, go work on your resume, go talk to a therapist, go, take a vacation, go out for, a run, whatever it is you need to center yourself. because as a legal matter, you're not losing anything by taking some time. You don't have to take action right after you are fired. In terms of whether or not it's worth it, then I usually go through a multi-step process with people. I mean, one of them, of course, is how strong is your case? What are you likely to be able to recover? If you were to go forward and win. And the other thing is, as you mentioned, are what we call non-monetaries, or the aspects that are not related to the check that your employer might write you. How important is it for you to stand up for yourself? How important is it for, let's say you've been the subject of sex discrimination and you've got a teenage daughter who's watching this, and you're like, I want her to know that this is unacceptable, and I'm not taking it. That's a different scenario from somebody who was like, what, this would not be a win for me if I didn't, get, 3 times what I'm being offered now, plus attorney's fees. Okay, well, then we got to analyze your likelihood of getting that versus someone who has another factor that they are considering that may weigh into that. And that's one of the reasons I wrote the book. And it's so important, I think, for folks, because, people who are going through it understandably they're not attorneys, or even if they are, they don't practice this area of the law, and they don't understand the legal ramifications and what the possibilities are. But the second thing is, people don't, attorneys, I think, and I've made this mistake too, tend to like, right, where you give an attorney a hammer and everything starts to look like a nail, right? Like, it's like we start analyzing things like, how strong is this case? Could I win it in trial? Which are all important considerations. But that takes somebody who's just been fired out of the center of the decision, and they should be in the center of the decision. Like, what does it mean to you, person who's just been fired, to go through this, and what will make you whole, and having the legal be the piece of that. And of course, other professionals like you or a therapist, because it's a multifactored, right? This is a big deal. It's, probably, just behind a divorce or losing somebody to death to lose, as you work with people like this all the time. It really is affecting, and to take all those factors into consideration.
So take a breather. Take a breather. You do not need to knee-jerk reaction, get on the phone, like make it all contentious.
Yes.
Take your time and just breathe through it to the best of your abilities. And so then you make the call. Then you're like, you know what? This is not something that I could walk away from, right? I mean, it's bad.
Yeah.
What is the, I mean, of course, there's no probably perfect clarity in terms of how long this takes, but typically when you are in, whether it's a discrimination, whether it's a termination, or even if it's something that is related to a non-compete, how long do these cases run for? Because in my case that I had around alcohol, right, and some discrimination against my alcoholism, one of the reasons why I didn't pursue it is because I knew it was going to take an extensive period of time for it to be resolved. And at that point, it wasn't worth it because I needed to move on. Was a single mom at the time, and I needed to move on and put that in my past. So what is the expectation that somebody who would be pursuing a case would have to think about, just like, because it's not going to be a weekend, right? I mean, it's not going to be like overnight.
I wish it were just a weekend. That would be great for everybody. And this is another thing I talk about in the book. One of the important factors that you raise, that this question raises, is how far are you willing to push? Again, no right or wrong answer, but to your point, like if we're talking about full tilt litigation, we're going into court, that sort of thing. I mean, it could be years. At least a year, if not more, to go through that entire process. So it is a considerable amount of time. However, and this is why it's important from the outset to really spend some time with your attorney, thinking about what your objectives are and taking that into consideration. Like, how long do I want this to be a part of my life? Because if you come to me, let's say you've been offered a severance, and it's a month of your salary, and you come talk to me, and I tell you, like, look, I think there was a discriminatory intent here. I think there's some evidence of that, and you tell me, like, look, I would love to just get 3 months of severance, so triple what I've got. Okay, well, then that might just involve me writing a letter to the company and having some back and forth and negotiating with them, that could be a period of months. In rare cases, it can be a week, but usually what's going to happen, I mean, weeks, but usually what's going to happen is it's going to take me some time to analyze it. It's going to take me some time to write the letter. It's going to sit on the employer's desk for however long until they get it to their lawyer. Then their lawyer's got to write the letter back to me or the email or call or whatever it might be. And their first reaction is almost always like, well, no, we didn't do anything wrong. And this is why, we are on the up and up. And what I'm looking for is for them to, is there room for negotiation without pushing further? Because a lot of times what they'll say, right, and you can just skip to the last paragraph of the letter, but in order to resolve this dispute, we are willing to whatever their offer is. And then you're in a poker game, right? And it's just a matter of, can we get close enough to your number that it makes it worth it to you? And depending on how strong your case is, like it may be a no-brainer. The company may easily offer, 3 times that severance. And that could be a huge win, even for people who have a really strong case, who might have a chance of winning it at trial. This is another good example of, attorneys need to not just be like, okay, knee jerk, like this is a great case, we should run off to trial. Because like you said, the person may be in a personal situation where they don't want to, nor do they have, months and years to pursue this. So to get an increased severance that gets them the cushion to be able to get to that next better job could be a huge win. So it really depends on how much your ask is, what you're looking for. And that's why it's important to spend that time up front with your attorney, right? Measure twice, cut once. So you come up with a plan that's workable for you.
There's a lot here. What I also am curious about is, and I do want to talk about this because age and ageism is a growing concern. I mean, obviously, no one is getting any younger. Are you seeing an increase in age discrimination cases? Are there things that we, as people who are in their plus 45, let's just say, can do to prevent or even to kind of see any of that in the early stages? I mean, most of us who are in the career transition space are concerned that there may be a reason and bias right from the beginning. And so there's nothing that you can do at that point necessarily, right? But once you start getting into a company, especially if it's in tech, which is clearly a very young landscape or tries to maintain that kind of exclusivity with respect to age and or other industries where things are so-called fast moving, how do you protect yourself if you are somebody who is not in their 20s or 30s?
Yeah, and absolutely, we have seen an increase in age discrimination. I mean, it's always sadly been very high, as you mentioned, in certain industries. Tech, sales, or is another big one where we see a lot of people 55 plus getting pushed out the door. But as the population has aged and will continue to, we are seeing more of that. On the plus side, I think there's more recognition because of the work like people like you are doing and others to kind of highlight that this is happening. So I think both employees are aware of it and employers are getting better, I think, in recognizing the value of people who are 40 plus. But that said, it is still very much a big factor. And if you're in the workplace, understanding that ageism exists, that it's illegal if you're over 40, that it is a real thing. And just like with any other discrimination, looking for being attentive to those signs that it may be, you may be on your way out and it may be on the basis of a discriminatory reason. Again, the comments that people make, like what are people saying to you? Like, are they saying something like, we've seen it, right? Like, we need new blood around here. We need somebody who's tech native, like all those kind of code words for we need somebody who's, under 40, paying attention to those sorts of things and any other changes that may be going on. All of a sudden that promotion that you thought you were up for, you get sidelined, all can be signs of a discriminatory intent. And it's with any other discrimination, keeping in mind whether or not you want to go to HR and say something about it, in writing, so you have that retaliation protection. again, understanding that in most instances, in my experience, once you go to HR, your job there is over. It's just a matter of time. So you might as well start looking.
Mm.
And then I would say, particularly for people who are over 40, you've got to have, I mean, it's a little bit cynical, but you've got to have your bag packed and ready to go, right? You need to, you need to know how to look for a job. You need, particularly for people who, and you see this, who've been in a job for years and years and years. And the last time they did their resume is when people were sending it by email attachment, and which I know still happens, but like that was the primary method, when they did it and they last did it, to just be prepared. And like I recommend to folks, particularly folks who are high level, they need somebody like you that they're routinely working with, even if it's just intermittently. So, if that happens, like I said, you've got your bag packed, you're ready to go. You can certainly deal with the legal angle, but I like to tell people usually, the best remedy for a bad job is that next better job.
Mm. Mm. It's a showstopper. Before we wrap this up, there's something else that I want to talk about because it's not the way that it used to be, which is severance, right? And as you are entering in a new job, we've recently had Carrie Lynn Shaw, shout out to you, to talk about compensation and salary and severance, to negotiate that right in the very early stages. Even if you have a severance package, maybe if you don't, what is your recourse at this time when you are, thinking of when you're concerned about getting fired or you have been fired? What can you do to potentially, morph that or add more to it or build a case? How can you leverage what has already been there and potentially even more, especially if there's discrimination?
Yeah, absolutely. Just because you've been fired doesn't mean you don't have a case. And in some ways, you have a stronger, or at least one potentially stronger aspect of it. And that is you've got lost wages, right? Like one of the biggest elements of recovery or damages or the check that the employer potentially could write to you in an employment case are your lost wages. If you've been fired, there's no question that there's a triggering event under the law, and you've got that clock ticking. And also the employer, if the employer has given you a severance, you have a certain amount of leverage. Even if there hasn't been strong discrimination, like they want that signature. They want, because right
Mm.
in that severance, you're signing away your right to sue for any reason. You're also probably agreeing to a non-disparagement agreement, which basically is you can't talk bad about the company, and they don't get that without your signature. So,
Mm.
you've got some leverage right there. That's why they make the severance offer. If there
Mm.
was some kind of discriminatory intent, that makes your claim even that much stronger. Because,
Mm.
the way I handle it and the way I would advise anybody to handle it is to say, look, you are asking me to waive all my rights to any claim I may have, and I believe I have one, because this, that, and the other happened. These comments were made, or there's this document, or I complained about the situation and then was fired, and you want me to release that claim? Okay, I'll do that, but it's gonna, you're gonna have to pay me more in exchange for that. So just to remember that you have that leverage. Another possibility, and this is true when you're still at work, but you do have some time before you have to do anything. But for discrimination claims, you can file with the EEOC, the Equal Employment Opportunity Commission. You don't have to have a lawyer to do it. It helps, but it's designed for folks who don't have lawyers. It's not public. In the sense that when you file it, like it goes on some like as you do in court, where everybody has access to it. It's not public. It protects your claims. There's an option for mediation there. Sometimes it's mandatory mediation, sometimes it's not. Regardless, you have that opportunity there, and it shows the employer like a certain level of seriousness. I don't want to
Mm.
overstate it, because the EEOC, great organization, but for the vast majority of people who file there, there's not going to be, the EEOC is not going to come riding up on their white horse to rescue you. But it does show that you're laying that next brick, that if you're, that's the next step you have to take before you can sue. And it buys you time and an opportunity to resolve your case. So know that if you're looking at that severance agreement, you in some ways are in a good spot to start that negotiation.
Okay, so there's a lot of different pieces, and I completely. I would love, love, love you to just give us a little bit, like a little taste of what we can all expect in your book, so that we are prepared and to be really like, if you are considering this, and I wouldn't even wait personally, I would just want to have this in my back pocket, because you just never know. And with the way that the turnover in the C-suite is, um, and just the increase, it's unbelievable. I recently read some statistics, very reputable, from Live Data, and it shared over the past 5 years that white collar executive layoffs were at around 6% and now are close to 18%. It's huge. It's
Yeah.
high. It's not, and I guess you could say there's kind of good news in it, because now it's a rite of passage. It's not like,
Right.
ooh, oh my goodness, it's so stigmatized. It doesn't take the sting away. I don't want to tell you that it makes it all better, but I'm just saying that there is support, and it is more common. Therefore, there are ideally more resources. So share with us what we can expect to find in the book, and I will certainly make sure that that link is in the show notes and all that great stuff.
Yeah, absolutely. And folks can find it. They can come to our website. I know you'll put the link, but spigglelaw.com. It's also up on Amazon. And I appreciate you giving me the opportunity to talk about it. The book is written from a layperson's perspective. It's not legalese. I wrote it for people who are not lawyers. And I walk through all the things that we've talked about here, because I really think whether you decide to pursue legal action or not, to give you the tools to make that decision on your own, and to, so you're not at sea. And so I think it's, to my own horror for a minute, and you think it would be not a bad idea to have the book before that even happens, because then if it does, you'll at least know where to start, right? I'm not
Mhm.
going to say by the end of this year, an attorney and ready to go. Not that I think anybody would think that, but you'll have some broad framework to kind of orient yourself, because I start by, explaining how you, as a person who's a non-attorney, can try to evaluate the strength of your own claim by
Mhm.
using publicly available resources, how to understand what the potential payoff could be financially for bringing your claim. And then I spend time in the book, as I did here, talking about kind of the non-monetary, what I call the non-monetary aspects, both the emotional and non-emotional, whether it's, the non-disparagement, or getting out of a non-compete, or getting them to agree not to oppose your application for unemployment insurance benefits. There are other kind of things that people are not aware of, I think, when they're facing these issues. So the book really does walk you through that and try to educate you on how an experienced attorney, would start to review your matter and help you make a decision. And I included a story of two folks, and Matt and Lynn, fictional characters in the book, who are going through this. So I really try to make it real for people, so that they understand, because my objective is to help people understand that they have options, right? Because as you mentioned, it's such a disempowering thing to happen. And I want folks to, it's not going to make it all better for folks, but for people to feel like, you know what, I've got some choices to make here.
Mm. Thank you, thank you, thank you so much, Tom. Just as a takeaway, as we were wrapping up here, if you had to wrap this up in one sentence, and here we are, we're midway, just about through 2024. Who knows what's going to happen? There's all kinds of uh, conversations. Ooh, it's an election year, but everyone's kind of in a wait and see mode with the economy, with the job market. What would you say to somebody, either in an organization about to go and start a new job, or somebody who has been, in their job search for a long time? What would you say to them about the current state, and how they might need to legally protect themselves, in one sentence?
Yeah, I think you're right. I mean, I would say I'll maybe take 2 sentences. It's a complicated time. So everybody's in the same boat. There are a lot of opportunities, but also a lot of hazards. And I think, an educated consumer is an empowered consumer. So go empower yourself, learn what your rights are and the signs to watch for. So when it happens, you're ready.
Thank you so much, Tom Spiggle. I will also make sure your LinkedIn and other contact information are included in the show notes, so that people can come and find you. And I also love that you're active on LinkedIn. You're not like regular lawyers. So thank you for that.
Well, thanks, Lauren. I appreciate all the work that you do and for having me on your show. It's been great.
Wonderful. Thank you.
Thank you for joining today. We appreciate your listening ears. Big time. We ask this: use these tools, not tomorrow, right now, and share them by spreading the love, leaving us a rating and subscribe so you don't miss the next career blast in a half. Most of all, thank you for you.